I welcome representatives from the Law Council of Australia. Thank you for appearing before the committee today. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee. Such action may be treated by the Senate as contempt. It is also contempt to give false or misleading evidence to a committee. If a witness objects to a question, the witness should state the grounds upon which the objection is taken, and the committee will determine whether it will insist on an answer. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may also be made at any other time. Questions on notice are due on 10 January 2020. For the Hansard record, could you state your name and the capacity in which you appear?
Yes, my name is Andrew Ham. I am a member of the Financial Services Committee of the Business Law section of the Law Council of Australia.
Thank you for joining us via teleconference today. For your information, I have in the room with me Senator Gallagher, the Deputy Chair. I'm Senator Brockman, the Chair, and we also have on teleconference Senator Patrick. Oh no, he's gone now. Sorry. So it's just Senator Gallagher and myself. So, did you wish to make some opening remarks, Mr. Ham?
Yes, please, Mr. Chair. I'd like to thank you on behalf of the Business Law section of the Law Council for this opportunity to appear and to give evidence in relation to this bill. Recommendation of the Black Economy, Recommendation 3.1 of the Black Economy Task Force, as I'm sure you know, proposed to introduce an economy-wide cash payment limit of $10,000. With payments above this amount being required to be made through the banking system. The recommendation is made in the context of observations that the use of cash is falling and that electronic payment methods are available as alternatives to cash. And the rationale for this measure is that, to quote, introducing a cash payment limit will send a strong signal to the community that it is not acceptable to avoid tax or other obligations by using cash as a means of payment. A cash payment limit will make it more difficult to underreport income or charge lower prices and not remit GST. This would therefore be expected to result in an increase in income reported and have a positive impact on the revenue. End of quote. While the risk of illegitimate evasion of GST obligations through the use of large cash payments is reduced by this measure, when the limitations of cash are considered in transactions where the buyer and the seller are not in the same place, it's likely that the cash in question will rejoin the banking system sooner rather than later in any event, and assuming that the receiving financial institution has adequate transaction monitoring arrangements and suspicious transaction monitoring in place, as is required under the AML-CTF legislation, a pattern of large cash deposits could reasonably be expected to be identified and investigated. A bank's AML program in these circumstances would typically include manual or automated systems to detect large cash payments or patterns of smaller ones, and would include inquiry as to the reasons for those deposits and the source of the funds. If the answers to those inquiries were not satisfactory, for example, because they were not consistent with other information known about the customer, such as their occupation, a suspicious activity report may be lodged. As the committee will be aware, suspicious activity under the AML-CTF laws includes suspected breaches of any state or federal laws, including tax evasion and other breaches of the tax laws. The existing AML-CTF laws can thus be seen already to provide an answer to the regulatory problem this recommendation of the task force was intended to address. Further, as these laws are risk-based, they require financial institutions to devote more scrutiny and attention to higher-risk transactions and customers. In the context of combating the black economy, one would expect accounts held by business that receive large amounts of cash to attract closer scrutiny, given the greater opportunity to engage in the kind of tax evasion that the task force sought to address by this ban. The bill establishes a criminal offences for strict liability for anyone who gives or receives a cash payment that equals or exceeds the cash payment limit of $10,000. The ban applies to all kinds of entities and to all payments in the broadest possible sense. It extends to payments that may be less than the cash payment limit, but which amount to instalments towards a single supply. Contravention is an offence bringing up to 2 years in prison or a fine of $25,200, if my math is correct. the Minister is to be given a power to make rules creating exceptions to the application of these offence provisions. It is the Law Council's submission that the unintended consequences of the bill outweigh the benefits of the proposed ban, and it should, at a minimum, be reconsidered and redesigned. The ban in particular is likely to have a significant practical impact on day-to-day business transactions and imposes a substantial burden on business and criminal liability on a large and potentially vulnerable proportion of the population. I can stop there if you wish, Chair.
No, that's fine. Thank you very much for that. Would you talk briefly through the issue of, the anti-tax evasion, anti-money laundering aspect to this bill? You believe that they are adequately covered off through other legislation? Is that your submission?
That is my submission, yes.
Okay. What's your contention here that the Black Economy Task Force?
No, just my contention is that large cash payments will eventually find their way back into the financial system in any event. That there are obvious physical limitations of cash in terms of how it can be used, particularly if the the buyer and seller are not in the same place, which means that for the reasons that the explanatory memo and the task force have identified, that as electronic payment systems and the banking system use of expands and the use of cash declines, cash is in fact less useful. So for example, a person has a large amount of cash and wants to use it for, say, to evade GST, the recipient of that cash would be limited in what they could do with it before it went back into the banking system in one way or another. And the banks, to pick on one particular aspect of the financial system, the banks have sophisticated transaction monitoring systems which allow them to detect patterns which are then scrutinised, so that if, for example, there's a mismatch between the stated occupation of a particular customer and the cash that seems to be flowing into the account, that would prompt further questions, which would then, at the minimum, trigger a suspicious matter report, and which would allow AUSTRAC to investigate.
Is cash ever used in the legal profession these days? Like, would any of your members be paid in cash?
It would happen, I think, in particular areas of the law. But I guess my contention is more one of principle rather than having a particular focus on the actual legal profession as transactors in the economy.
No, fair enough. I was just wondering. Senator Gallagher.
Yeah, thanks. And thanks for your summation, Mr. Ham. I'm sort of, each witness that comes along gives me another sort of line of thought, but I'm sort of trying to put a bit of this in perspective with my own experience. So last century, I worked for an organisation that would have taken $50,000 in cash a week. This century, they'd be lucky to take $500 cash a week. So given that transition's occurred from my personal experience, and generally the Reserve Bank, I think, is saying there's much less cash payment in the economy, why do you think this is seen by some as, if not a silver bullet, a sort of precursor to stamping out the black economy?
I think that if you're asking me, Senator, about the reason for the ban, I see it as being there's an assumption there, if you like, that the use of an amount of $10,000 cash in almost any business transaction these days is without excuse, and that it goes without saying that it will be for the purposes of evading GST or other, illegitimate money laundering sorts of purposes. And my contention is that there are a number of unintended consequences in where that assumption might be open to challenge, and that I suppose that it's not a valid assumption in some cases, and that the people that are therefore exposed to really, criminal consequences, 2 years in jail, are particularly, excuse me, my voice is rapidly disappearing, but I hope you can understand me.
Yep.
The people that are exposed to criminal consequences as a result of that ban are, the people at the front line of business. So, in retail and wholesale businesses, the people that are dealing with customers. And so many of those people are minimally paid, minimally trained, minimally engaged with their workplace. They might be casual or part-time. They might be 16 years old. And under this bill, all that has to happen is someone, for whatever reason that may or may not be valid, wants to give them $10,000 to pay for something, or maybe it's a $5,000 deposit on a $10,000 item, and that person is potentially heading to jail. And that disturbs me greatly, particularly when you think of I have 2 children that work in the retail sector who are not 18, and that's a substantial burden on them and a substantial burden on their employer to train them, which I think in the current environment it's not realistic to expect. My own children's experience, I know, is that they were hired and they were on the shop floor within half an hour of arriving after they've been shown how to work the till and had the stock explained to them.
Okay, and I think there's a submission, I think, from the Flight Centre. So if, for argument's sake, if a couple just saved up for their holiday $200 a week and it came to $12,000 and they just went down to the Flight Centre and gave them $12,000, your argument is if the person who receives that is not well trained and across all the detail, they would be breaching the law.
That's correct. It's a strict liability offence. The Act is all that is required.
Why do you think the 10,000 was agreed upon, or do you think that there was because the other lower figure would have caused too much concern?
I think I guess it's an arbitrary judgment call where you draw that line, and I think it was a convenient figure to pick because it aligns with the threshold transaction reporting regime under the AML-CTF laws. So from that would mean I understand that there is a proposal to in the rules to have an exemption for enterprises that are regulated by the AML-CTF laws. And so this would mean that any transaction is either banned or is subject to reporting by the regulated entity.
Okay, some of the earlier evidence we had is that over a period of 10 years, the 10,000 limit will actually have reduced with inflation, and we'll be capturing a whole lot more of the economy. Do you agree with that?
Yes. I guess I would, but I think that's in the scheme of things, I think that's a lesser consideration. I guess I'm more concerned about, if you like, from perspective of legal principle, and if you like, the principles of justice, that there are a number of larger issues in play here. I guess my other major concern is just the impact on business, that, again, in order for businesses to be able to track instalment payments, which would be captured by this ban, and to be able to defend themselves if there was ever an accusation against the business itself, they're really going to need to potentially rebuild their whole finance system in order to identify when they are in receipt of cash as payment, or indeed pay cash, or whether it's some other form of payment. And that's a ground up, potentially enormous IT exercise.
Okay, so just on that, so if someone was to go in and pay $3,000 a month for a holiday until it got to $12,000, you're saying that the record keeping is all on the business, and as soon as they hit $10,000, they're potentially in breach of the law. And who gets the fine or the jail? Is it the owner of the business or the person doing it?
Well, and that's another issue. It'd be both, because the individual, the staff member, could be argued to have done the physical act. They've accepted money, and again, there's no ignorance that it's over the level. It's a strict liability offence. There's no intention element, and secondly, it would be up the discretion of the prosecutors, of the police, and presumably the DPP, as to whether the company was pursued, or the customer, or the staff member, or all three.
Who would be policing this this level of exchange of cash versus GST?
Well, as I understand it, there is no one policing it, but it's not within the purview of any particular regulator, and so it's really just the discretion of the prosecutors, which was another concern, that there's no particular authority or body that is responsible for issuing guidelines that would help business and customers to understand how they might apply and really address the exact question you just asked.
Now, we had an interesting submission from the opal miners around the country who face vagaries of the internet and no banks and cash buyers. So how would they transact in this new world?
Indeed. So, and you come back to the generalisation that electronic payments are increasing in penetration and cash is decreasing, but it's by no means uniform.
Okay. So, finally for me, so your contention is that at the very least there should be amendments made, there are unintended consequences, and there is a body of work going on which addresses this problem anyway.
Yes, and I'm aware that there is some draft rules circulating, but I suppose the other two points I'd like to make is that it would be a very difficult law to enforce, because you can imagine, you're in court, you'd almost need an eyewitness to say, I saw, this guy in the shop, took $10,000 from, this customer, and that's wrong. So unless you're really unlucky and you're in line behind a federal policeman or something, it's entirely plausible, I think, to have concern that there's a law here that may be not enforced in the ordinary course. I understand there's no real plans to publicise it, so it may well be widely not observed, just through ignorance, and then there's risks of, if you like, arbitrary enforcement, and which brings up basic principles of justice. And why is one person, imagine it's like a speeding fine. Why is one person picked out of line of speeding cars and prosecuted when another one isn't. And that again, from the perspective of sort of fundamental legal principle, would be of concern, particularly when you think that many of the people in the firing line will be, as I say, relatively vulnerable people who may well be minors, as in children.
Okay. Finally, from me, I have an ABN number from some previous activity before I came to Parliament, but I haven't used it for 10 years. But I think, I've still got it. So does that mean that I would fall under this purvey of this law, or do you have to go and cancel them, or do they just fall away, or what do they do?
Well, it's I understand there's an exception for personal transactions. So if you accepted the money in the course of a business and it was, yes, you gave a receipt, say, with your ABN on it, then theoretically that would indeed, as I understand it, capture you.
Okay. All right. Thanks very much.
So Senator Brockman again. So we have heard from a couple of witnesses about this issue of levelling the playing field. So you'll get some small businesses saying that their competition are undercutting them through the use of cash, and if they're doing the right thing, that they're not competitive. Do you have any views on that issue?
I understand the point that people that cheat and don't obey the existing law are gaining a competitive advantage. I think that it's a balancing act. So I guess my contention would be that this particular solution has other quite, in my view, alarming consequences, which which don't necessarily mean it's the right way to address that problem.
All right. Well, Senator Patrick, you're not on the line, are you? No. In that case, thank you very much for your time today. We will suspend until 1:15 with the Reserve Bank of Australia.